I think we're going to get started, given the disruption from not having the Zoom set up properly. I apologize to everyone for that. I really prefer the interaction of give and take and questions and answers. So the webinar format generally doesn't allow for live interaction. And so we have to shift it to the meeting format in order to be able to take questions or comments. So that's what just occurred. So we should be able to do that now. On the other hand, I do want to qualify what I just said, because if you have comments or questions, please absolutely ask them. But I will be policing that. And if I'm either trying to get through the content of the presentation and it's just not going to be possible with the number of questions, or I feel a question is not relevant or is going to be answered later, I'll tell you that. And I'd also appreciate it if questions were really focused on generalities, not on, let me tell you the 20-minute story of my child and what they experienced, because that's just becomes unmanageable in terms of putting me in the position of giving legal advice, which I'm not allowed to do, and consuming a lot of airtime for other people who may have questions as well. I do want to welcome Joanna Barnes, who's a longtime advocate who I've known in the past from, I think, where are you from, Joanna? I don't remember.
I'm from Washington, D.C., but I live in Chapel Hill, North Carolina.
That's right. I wasn't sure if it was South or North Carolina. David Beinke is also on, who's a longtime COPA activist and COPA board member, and doing great work in Texas and actually all sorts of places around the country. Chris Palmieri has also joined us, and Chris is an advocate working as one of the advocates in our office, and she has a particular skill at navigating the dark recesses of the Chicago public schools and figuring out how to deal with the bureaucracy and access the higher ups there. So we're very happy to be having her assisting us in the many cases that we have involved in Chicago public schools. So this presentation is going to talk about the various ways that IDEA Section 504 and the ADA are similar and different, how they operate to work for and protect kids with disabilities and or don't work for and protect kids with disabilities. And as we go through it, I'll provide some embedded kind of commentary on what the pros and cons are of the different laws in relation to specific situations. And then I'll try to provide a bit of a summary at the end of what the pros and cons and strengths and weaknesses are of the different laws. It's actually, I particularly appreciate David being on the call, because although I don't know all of the details of it, it's my sense that in Texas, as is true in a number of states, Section 504 is a much bigger feature in the provision of services to kids with disabilities and the protection of the rights of kids with disabilities, where in many other states, such as Illinois, Section 504 is sort of the poor stepchild of special education and the place where kids get parked when they need a little bit, but not very much, and the school isn't very serious about doing anything. And so certainly if David, you or others from states that have strong 504 kind of procedures have comments, certainly eager to hear that as we go along, to the extent that it might illuminate some of the points that I'm trying to make. At the outset, I just want to talk about how schools are covered. Sadly, many parents and some educators continue to struggle with the lack of understanding of the ways that the different laws apply. And I also do a fair amount of work with families whose kids are in private school, and these laws have somewhat different implications with respect to their application to private school as compared to public school. So the first thing that is important to understand, the three laws are the Individuals with Disabilities Education Act, the Americans with Disabilities Act, and Section 504. By the way, this outline will be posted on our website. There are already several articles comparing IDEA and Section 504 on our resources page on our website, but this one has been updated and will be posted after the presentation, or certainly within a week or so after the presentation. So the first thing to understand is that IDEA is a statute that provides federal funding to school districts, and it tries to strike a bargain with the states. In effect, what IDEA, the Congress said, was we're going to give you a whole bunch of money. In exchange for taking the money to serve kids with disabilities, you have to agree to play by our rules. And the IDEA, which was originally passed in 1975 as the Education for All Handicapped Children Act, was intended to cover 40% of the total cost of special education in the United States. In fact, as most of you probably are aware, the federal share of special education has never gotten close to 20%. It's typically hovered between 15 and 17% of the total cost of special education. And as we all experience, there are almost constant financial pressures, concerns, and conflicts over services under IDEA. And wow, it sure would be nice to have a couple of extra $1 billion of services available to train and support teachers and kids to provide more appropriate education. In fact, I would go so far as to say that although IDEA is not an unfunded mandate, it's has some of the same complications that people might use to attack what are called unfunded mandates, because it sets a very high bar in terms of what's required of schools, or at least conceptually a high bar. And then the lack of adequate funding, training, and enforcement results in services being often, if not pervasively, far less robust and adequate, and procedural compliance being far lower than it should be. But in any event, it's now the case that all 50 states accept federal funding under the IDEA, so all states are governed by it, and all school districts that are public school systems in the United States are required to fulfill the requirements of the IDEA, which then in turn leads them to enact state laws and regulations that are for the purposes of implementing the IDEA. It's also important or worth noting that in general, state law cannot contradict the requirements of the IDEA. State law can fill in gaps for things that the IDEA doesn't cover, and state law could provide more protection than the IDEA does, but it can't negate or provide less protection than the IDEA does. An example of that is that, and there may be other states that do this, but for example, I know that the state of Michigan provides special education services for kids through the age of 26. That's permissible because it's providing more protection than the IDEA allows, but they would be violating the IDEA if they provided services, let's say, that cut off at the age of 16 and didn't provide services through to the age of majority. So be aware that it's important to consult the laws of the state, and also be aware that sometimes states and school districts play games with their interpretation of IDEA, so they adopt rules that are ostensibly neutral, but in fact have the effect of either expanding the rights of kids, or in some instances contracting the rights of kids and limiting what they're able to do, which sometimes does lead to either complaints to the federal government or litigation. By contrast, Section 504, which actually was adopted in 1973, prior to the enactment of the IDEA in 1975, it's a very short law. It's only a paragraph long, and it basically says it's illegal to discriminate on the basis of disability in any program that receives federal financial assistance. That can include states, it can include school districts, it can include private corporations that have federal contracts. There are many different organizations that receive federal financial funding, but there has to be a funding stream from the federal government that's direct in order to trigger Section 504 applicability. Importantly, Section 504 generally is viewed as not covering schools unless there's some type of a direct grant to the school for a specific service. There's ambiguity with that, though. We've had cases, and there have been other cases around the country where there's been a dispute about things like the school district, the private school rather, gets funding for its free lunch program or a subsidized lunch program. The private school gets money from the federal government to subsidize the purchase of computers, which people may not be aware, but there's a huge national program that underwrites the cost of computer purchases in public and private schools. We even had a case against a very big and prestigious private school called the Lab School in Chicago, which is on the land of the University of Chicago. It has a variety of different connections on its website to the University of Chicago. It has things like the University of Chicago Title IX office regulates compliance with the lab school's operation, but they claim that they're not governed by Section 504 because they don't get any direct funding under Section 504. So that's an area of ambiguity, but in general, it's reasonable to assume that most private schools do not get funding for special education or other things from the federal government. The exception to that, so everyone is very clear, is if a private school is contracting with the state and the school districts to provide services to kids with disabilities, it's highly likely that they are getting IDEA flow-through dollars, and arguably they would be covered by Section 504. The final category is schools that are covered by the Americans with Disabilities Act. The Americans with Disabilities Act does not require that an organization receive federal funding in order to be covered. It covers all public and private entities that provide services or are open to the public, including private schools, private colleges, private universities, private hospitals, with the exception of organizations that are religiously controlled. That was an unfortunate carve-out that occurred from the religious community when the Americans with Disabilities Act was being adopted. And so we're in an anomalous situation where there may be some private schools that are covered by 504, but not by the ADA. There are absolutely many schools that are covered by the ADA, but not Section 504. And then sadly, there's a fair group of schools that are private religiously controlled schools that don't take federal money, that probably are not regulated by any federal statute. It's worth noting in situations where there's no federal regulation that it's worth checking to see if your state or even your county may have statutes or regulations that do require that organizations refrain from discrimination based on disability that may be applicable to those schools. So lots of different ways that schools are covered, and the rules for those schools differ in terms of which law applies and how it's determined whether they apply. The other thing that's important to recognize is that IDEA does not apply. Many parents are confused about this. IDEA does not apply to higher education at all. There are no IEPs when you go to college, technical school, vocational school, or university. Section 504 generally does apply because most universities accept federal funding, and it's certainly especially clear in public universities. And generally, the Americans with Disabilities Act applies to most colleges and universities, though again, if it's religiously controlled and does not take federal money, it may not be regulated by either one. All right, any questions on that? Okay, so then the question is, who's covered by these laws? Which kids are entitled to protection? Hello? Okay, the IDEA has multiple categories of disability that are laid out in the law. A child has to qualify for at least one of the categories that are specified in the IDEA, and they may be eligible based on multiple categories, but each category has its own criteria. And importantly, It's not enough that the child meet the criteria for having the disability. The disability has to result in a determination that it's causing an adverse effect on educational performance. And I'll talk in a moment about what that means. And it has to result in a need for special education instruction. And I'll talk about that in just a second as well. But many times schools acknowledge that a child has a disability, but they refuse eligibility for special education on the grounds that the child either is not displaying an adverse effect on educational performance, or may even have an adverse effect on educational performance, but is not in need of special education instruction to ameliorate that performance. It's important to be aware that Section 504 and the ADA both apply to public schools, but in general, when we are looking at issues of services and discrimination, if a child is not qualifying under the IDEA, or there's a problem that may not be covered by the IDEA, we tend to look at Section 504 as the source of guidance and direction for what public schools are supposed to do, far more so than we look at the Americans with Disabilities Act. And that's in part because the Congress and US Department of Justice and other federal departments interpret those two laws based on something called parallel interpretation, which means essentially that they impute the requirements of 504 to situations where the ADA is involved, and vice versa. They impute the ADA requirements to situations where 504 is involved. And really, because 504 was the first kid on the block and the ADA was Johnny come lately, the orientation is there's much more specific guidance relevant to schools in 504. There's a longer history of litigation and interpretation under 504 as compared to ADA. And so generally speaking, we rely on Section 504. In addition to that, the schools are not required to provide the same level of enforcement, monitoring and enforcement under ADA as they are under 504. And in fact, the federal government's enforcement is different and somewhat more inaccessible under ADA as it is under 504. That's a subtle point, but important in terms of choosing which law you're going to be using. One of the things that's also important to be aware of, though, if you have a dispute that involves a child with a disability, if you bring a case and allege that the child was denied services under the Individuals with Disabilities Education Act, there's a requirement for something called exhaustion of administrative remedies, which requires you to go through a due process hearing procedure, even if you also are pursuing a claim under Section 504 or the Americans with Disabilities Act. And sadly, there are a number of court cases that have held that basically a child and family can't bring a case under either ADA or 504 unless they've exhausted the remedy under IDEA. So it's important, if you have what you perceive to be a good and even relatively pure 504 or ADA claim, to not contaminate it by potentially adding an IDEA claim that may confuse things and force you to have to go through an administrative process in order to bring the ADA and 504 claim to start with. In any event, by contrast to IDEA, Section 504 is non-categorical. There aren't any of the 13 categories that IDEA has. There's no requirement that you meet the rules for a specific disability. All you need to establish, and you can do it generally based on provision of evaluation from any clinician who's competent to evaluate and diagnose a disability, is that the person has a physical or mental impairment or disability that substantially limits a major life activity. And the major life activity includes almost anything: thinking, hearing, concentrating, socializing, walking, working, paying attention, reading, writing, etc. So a wide variety of different types of life functions are implicated by Section 504 and by extension by the Americans with Disabilities Act. And so the one way to conceptualize this is that every kid who's entitled to an IEP would by definition be entitled to a 504 plan, but many kids who are entitled to a 504 plan are not entitled to an IEP because the criteria for a 504 plan are much broader than the criteria for an IEP. It's important to be aware schools will frequently take the position that a child who's getting passing grades or receiving scores on achievement tests that indicate at least modestly average or above average achievement is not experiencing an adverse effect on educational performance. That's incorrect. Educational performance includes not only academics, but social skills, communication, motor skills, executive functioning skills, paying attention, getting your work done. And indeed, one of the things I love to argue when schools make this preposterous argument is I just get out the report card and ask them to review what's on the report card. And typically the report card has almost as much, if not more, information on non-academic performance as it does on so-called academic performance. The two are actually quite intertwined, but in any event, schools generally, and indeed the state departments of education and their state standards typically are trying to develop children as learners, not just from an academic standpoint, but from a social, emotional, and life skills standpoint as well. So schools may argue that adverse effect on educational performance narrowly applies and that a child who's doing okay academically doesn't qualify. As far as I'm concerned, that's a lot of hooey, and you should not ever accept the school's position on that. It's almost impossible not to find some part of the child's disability that doesn't have some sort of impact on their educational performance. Nonetheless, the provision of 504 that's a substantial limitation on a major life activity is much broader. And then the final requirement, as I mentioned before for IDEA, is that the child has to need special education instruction, whereas under Section 504, the child can qualify based on the need for special ed or related services, in other words, things like therapy or nursing services, or the provision of accommodations that will assist them to access the instructional material and the functioning in the school day. So again, the criteria for what is required to qualify for a 504 plan is much broader than the criteria for what's needed to qualify for an IEP. Nonetheless, again, schools tend to present the definition of what constitutes special education in a very narrow and sometimes very selective way. So if a kid is having big behavioral problems and they want them to be moved to a special ed classroom or school, they interpret their behavior as having an adverse effect and requiring special ed services because the teacher's got to be involved in serving them. But if the child's getting good grades and achievement test scores and is not a behavioral problem, but can't do their homework, can't organize their work, can't plan their time, can't socialize, and is sitting alone in the back of the room every day, they don't see that as being an instructional issue. They see that as being something that just requires accommodation or related services. Obviously, that's hypocritical and inconsistent, but it is important if you're advocating for a child to have an IEP that you have some identified instructional service in which a special ed teacher, not a therapist, not a social worker, not a psychologist or an occupational therapist or speech pathologist, but a special ed teacher is going to be doing something for that child. It could be in a co-taught class. It could be in what some places call a resource room where the child's just pulled out for a period or two a day. It could be in a study skills class. It could be in a self-contained classroom for part of the day, but not all of the day. It could even be, in my view, this is a little bit less widely accepted, it could be that the child gets what are called check-in and check-out services from the special ed teacher or case management services from the special ed teacher. It could possibly even be that the regular ed teacher gets consultative services from the special ed teacher to support them in serving the child in regular education. But in any event, there has to be some role for the special ed teacher, or the school's going to say this isn't a special ed service and deny eligibility. By contrast, a kid can qualify based on receiving accommodations under 504, related services like the kid has ADHD and needs the nurse to administer meds at the end of the day, or middle of the day rather. That's a related service, or social work counseling services. Interestingly, though, the 504 regulations make clear that a kid may also need Section 504 special ed services. And quite remarkably, although it almost never happens, Section 504's regulations make clear that under some circumstances, a kid may be entitled to residential placement under Section 504, one of the most expensive services that can be available for a child with a disability. The reason that schools favor using or distinguish using Section 504 and prefer it is when it doesn't cost them any money, because under most states' reimbursement structures, the school district isn't going to get any reimbursement for Section 504 services. They're going to have to provide that without the help of the state or federal government. So if they're going to have to do it in effect on their own dime, they'd rather limit the Section 504 services to the services that are basically easily implemented without extra cost, extra staff, extra technology, or whatever. By contrast, in most states, the special ed, not most states, all states, special ed services are reimbursed and funded with money from the state government and typically flow through dollars from the federal government. And so there's a reimbursement structure. And so an artificial distinction has developed where school districts tend to view special ed as the place where they put more expensive services that they have to pay for, and has put accommodations and support services under 504 where there's no cost and they're not perceiving themselves as having to spend extra money on that. So that's a very artificial distinction, but nonetheless, functionally, most states have very arbitrary lines between the kids who get or qualify for 504 services and those who qualify for an IEP. And the other thing I want to just mention is that, I first read this many moons ago, it kind of shocked me that the Congress had omitted this, but IDEA is not a civil rights law. We all would argue that IDEA conveys civil rights to a free, appropriate public education in the least restrictive environment and so on. But IDEA doesn't say anything about discrimination on the basis of disability, except in the arena of Norma, could you mute, please? Okay. IDEA does prohibit discrimination on the basis of disability in the use of testing, but there's no more generalized rule that prohibits discrimination on the basis of disability. By contrast, Section 504 and ADA do have an express prohibition on discrimination based on disability. And in fact, as some of you may be following some of the litigation that's developing around the failure to provide appropriate services during the pandemic and the possible right to compensatory services, some of that litigation is being based on IDEA and the requirements that it has, but some of that is being based on discriminatory treatment under Section 504 in the ADA for providing a different level of access or service to kids with disabilities relative to what they need in comparison to kids in regular education or even kids with milder disabilities in special education. Importantly, also, Section 504 and the ADA also provide protection against disability for children who have a history of disability. For example, a child who had a disease and has now been cured of the disease, but the school may be saying we're not going to allow someone with that disease to be in our classroom, even though they don't even have the disease anymore. So a history of disability may be a basis for discriminatory action that would be protected under 504 and ADA. A second category that's protected under 504 and ADA that's not protected under IDEA is a perception of a disability So someone is seen as having a disability when in fact they don't have a disability. They just have, let's say, a different personality, or they're shy, or they don't like to do something, but it's not because of a disability. It's just something that's related to them, that they may even be subject to discrimination because their parent had a disability. The child can hear, the parent is deaf, but the school treats the child as if they're deaf, even though there's no hearing impairment. And then that leads to the third type of disability discrimination that is present and covered by ADA and 504, that's not under IDEA, and that's what's called associational discrimination. And the best example I can give of that is a case I actually litigated, where my primary client was a young boy with ADHD who was being denied a free appropriate public education and being denied services he needed, and was being subjected to various forms of inappropriate discipline. But we added his sister to the federal court complaint that we filed on the grounds that the school was saying to his sister, who did not have a disability at all, it's your responsibility to come down and control Joey and make sure he behaves, or we're going to have him arrested and taken out of school. And we argued that she was being discriminated against in violation of 504 and the ADA on the basis of what's called associational discrimination. They weren't asking any kid in the school to come down and get Joey to behave. They were only asking his sister to come down. And so her association with him as a relative was leading her to be subject to discrimination, because her education was being disrupted and she was being put under an impossible, emotional burden to be responsible for her brother's performance at school, which no 11-year-old should have been responsible for doing. So multiple different ways that these laws apply. I want to make one other comment about the private school, public school business. We often work to get kids placed in private schools, and sometimes those schools are in the Chicago area, and we develop very cooperative relationships with them at times. But almost every major private school in the city of Chicago or environs has been on the receiving end of a complaint or lawsuit from our office at some point, including, by the way, not just private special education schools, but also not excluding private special education schools, but certainly very much including some of the best high-end college prep schools, fancy dance schools. And we've had some success, some failures too, but some success in getting substantial remedies for kids who have suffered discrimination, and in some instances been disciplined and dismissed from private schools because of the failure of the private schools to accommodate their disability, and because their ultimate behavior, given the failure to accommodate, led them to get in some sort of disciplinary trouble that resulted in an inappropriate discharge from the school. The tricky thing about all of that, by the way, is that unlike a public school, there's no mandate to provide service no matter what. Though even in a public school, we frequently have to talk with parents about, do you really want your kid to go back into this hostile environment? And when it's a very hostile environment, we have to think about what might be alternative places for this child to go that would be safe and psychologically, emotionally, and educationally secure for them. Then the final thing I want to mention in terms of coverage issues in relation to IDEA 504 and ADA, IDEA does not address the issue of mitigating measures, whereas in 2008, the US Congress, in response to some very bad court cases from the US Supreme Court in relation to 504 and the ADA, said that it was illegal now under the Americans with Disabilities Act and the 504 to discriminate against a person based on the absence of disability when the grounds for finding that there was no disability was that the mitigating measures that were being employed to assist the child neutralized the effect of the child's disability. So that examples of that could be that the child has ADHD and takes medication, and when they're medicated, the symptoms are not as acute. The child has an executive functioning deficit or a learning disability, but they're spending 3 or 4 hours a night more than the other kids in the class are completing homework. Or in parallel with that, not only are they spending many hours extra completing the homework, but they are getting enormous support from their parent or even from private tutors or therapists. So there are a variety of things that schools have used to say that the child's doing okay. We don't think they have a disability because we don't see it, where the reason that they don't see it is because of the mitigating measure. If you're able to identify the impact of the mitigating measure, then that should be a basis to say that the school can't deny eligibility on that basis. All right, just to be somewhat broad, but nonetheless, the rules for evaluation and reevaluation under the IDEA, which are necessary both for the initial eligibility decision, for planning for the coming IEP for the next year, and are required under IDEA to be done at least every 3 years as a kid remains eligible, and then prior to termination of eligibility. Those rules are also very specific about the parent's right to have input into the testing process, the parent's right to have access to the results of the testing, the requirement that the testing be non-discriminatory, the tests that are being used are have been researched and proven to be effective for the particular thing that is being evaluated, and that appropriate accommodations and supports are made so that, in fact, the results that are being obtained are accurate. And in 2004, the Congress passed an amendment to the IDEA, which to me was profound. One of the things that they did when they amended it was they said that the IDEA now required that the evaluation process lead to results that were accurate about what the child knew and could do. And that was incredible to me for 3 reasons. Number one, that 30 years on, or whatever it was, 30 years on, they had to pass a law saying that the testing that the schools did had to be accurate. Well, that's shocking. That raises the question that they were concerned that for the preceding 30 years, schools had been doing testing that was not accurate. And frankly, I think that's probably accurate. I think it continues to often be accurate today, that schools often do testing with results that are not accurate. The second thing is that it talked about that it's got to be accurate about what the child knows. And that's important because sometimes what a child knows is different than what they can do. And it had to be accurate about what the child can do, which is sometimes different than what they know and can reflect or report on a test or in a conversation. And so that really shifted the focus on what I would call, and developed after 2004, an increased recognition of the importance of what's called functional performance, which is it's not enough to just look at how a kid performs on a test in a clinician's office. It's important to look at what they're actually able to do in the classroom or the real world. And one of the places where this is the most concerning is the use of IQ tests, which are notoriously, I think, subject to misinterpretation, misuse, failure to adequately accommodate, failure to adequately target, and oftentimes test things that are not the thing that's intended to be tested, but instead test things that are unrelated, like giving a test in English to a kid who's primarily speaking Spanish or another language, which obviously leads to a very low result that has nothing to do with the child's ability to think, but only their ability to speak in the language of the test being given. So this is very, very important. And if anything, IDEA 2004 strengthened the rules relating to testing on the whole. Section 504 generally tracks, but in a very general way, the protections requiring accurate, effective, and non-discriminatory testing, but it doesn't have the same detailed rules that are present under IDEA. And importantly, it doesn't have the same schedule of testing that's required for more limited testing at the annual review, mandatory in-depth testing every 3 years, and testing prior to a termination of eligibility. The only thing that 504 really says is that the testing has to occur before any significant change in the plan and periodically thereafter, so much more vague. The other thing is that IDEA contains an explicit requirement for child find that includes the requirement to search the community and identify kids suspected of having disabilities and evaluate them, including the kids who are on homebound, including the kids who are homeschooled, including the kids who are in private schools, even if those kids live in districts other than that district. Section 504 does not have much in the way of those types of specific child find requirements. Pause for a second for any questions. Okay. Then like to talk about the substantive requirements of IDEA 504, and the two that the language that's arguably the most important, and surprisingly to many, both IDEA and 504 contain a requirement that kids with disabilities are entitled to receive a free, appropriate public education. But although they use those same 4 words, they mean something fairly different under the 2 laws. Again, and this is an ongoing theme with respect to understanding the differences between 504 and IDEA. The language in 504 that addresses this is very short and general, and defines the right to a free, appropriate public education as being based on meeting the child's individual needs as adequately as the needs of students without disabilities are met. Whereas under IDEA, the child has a right to receive an individualized educational program that is specifically designed to meet their unique needs and that is inclusive of special education and related services as may be necessary for them to be able to function adequately in school. So even the broad definition under IDEA is much more, in my mind, directive and inclusive than the definition under Section 504. But the 504 rules pretty much stop after that, whereas the IDEA rules go on at great detail and length to talk about the right to have all of the child's needs that may or may not be related to their disability identified, to have goals and objectives developed that respond to those needs, to have the goals and objectives monitored on at least a quarterly basis, and for there to be data collected and reported to parents on the child's progress at least as often as kids in regular ed, as well as at specified intervals, to have short-term benchmarks or objectives. And then some things that are just very powerful, like that the educational program should be based on research-based practice to the extent practicable, and that the IEP is supposed to specify the starting date, frequency, nature, and location of all services. So these are very important, detailed directives to schools. I was just talking with a staff member today, and I suspect many of you on the call experienced this with your own child or with kids you're advocating for. I think it's almost impossible for a school district to write a perfect IEP. I think in all of the years that I've been practicing, there's never been an IEP that I couldn't find some basis to critique it or say that there were problems with how it was drafted, constructed, or things that were omitted from it. Certainly, sometimes they're very good, but it's virtually impossible to be perfect. But in any event, very, very detailed requirements, and requirements for things like addressing behavior, the need for assistive technology, the need for transition plans, and I'll talk more about that in a minute, and very specific rules that call for the parents to be participating in and have the right to meaningful participation in the process of reviewing and adjusting the IEPs. By contrast, 504, there's a general right to parent participation, but there aren't specific rules about what that participation is supposed to look like. There is a rule that says that school districts may use IDEA procedures in developing the contents of a 504 plan. And sometimes school districts do that, but they're not required to use IDEA procedures for the purpose of writing 504 plans. And in my experience, the 504 plans tend to be enormously more general, not subject to the same frequency or consistency of review and updating, not clearly describing exactly what educators are supposed to do. And oftentimes the 504 plan, and this, by the way, is in my mind is a mistake and not something that parents should allow for their child, but the 504 plan is written to define what the child is supposed to do, not what the adults are supposed to do. So it will say things like, the child will ask for extra time when needed. The child will request the opportunity to take the test in a quiet environment as needed. The child will seek additional tutorial support when needed. Those are oftentimes guarantees that the child's not going to get the help that they need. And in any event, it puts the burden on the child. The most extreme that I think is outrageous, I've had schools that said that a child would initiate the request to go to the principal's office or the nurse's office to get their medication. And sometimes that was even more outrageous because the medication was to treat them for ADHD and the medication was wearing off. And yet the expectation was that they would have the wherewithal to say to the teacher, oh, I need to leave class to go to the nurse to take my ADHD medication. Ridiculous, stigmatizing, ineffective, inappropriate, and from my standpoint, illegal. The school should be doing what's necessary to ensure the child gets the support they need, not putting the onus on the child. Now that might lead to a question about what does that do in promoting dependency by the child on the external supports? And that's a question that actually can be raised with respect to all accommodations. And it's important to distinguish in terms of accommodations versus goals. In my mind, schools, parents, and clinicians often mistakenly, and this, by the way, is true under IDEA and 504, schools often mistakenly say, we're going to provide an accommodation for this child so they can use books on tape to read, and they can use a calculator to do math, and they can use a computer calendar program to keep track of their assignments. Great. That's a way of allowing them to ensure that they're not drowning in the moment when they're having to work on the content of whatever the class is that they're doing. But using a book on tape does not teach you how to read. Using a calculator does not teach you much about how to compute. Using an electronic organizer does not teach you very well how to chunk assignments and keep track of assignments. Those are things to keep you afloat. They're not things that teach you. And so it's important to recognize, in schools often, I've had many schools say to me, you can either accommodate or you can have goals. You can't have both. And my reaction to that is absolutely wrong. You can and often should have both goals and accommodations, because the intention is that the child over time will develop the skill to be able to do the task on their own. But while they are learning the skill to do the task on their own, the purpose of the accommodation is to allow them to continue to function and get benefit from the educational program. So very, very important to hammer again and again, accommodations and goals are not mutually exclusive. And in fact, to the contrary, they frequently are things that should be used in concert with each other. Okay, then, so I just want to highlight back to the FAPE standard. I would hope everyone on the call is aware that historically the IDEA FAPE standard was governed by a very famous Supreme Court case from 1982, the Hendrick Hudson School District versus Rowley case. That case was often known to mean, or understood to mean, that a child was only entitled to enough education to allow them to get some benefit from their education. Another way that that was understood was that the child only is entitled to get a Chevy, not a Cadillac, or the most service. That was in many ways a misnomer, in my view, because the IDEA, in fact, contains many details about the content and quality of a child's education that go well beyond what might be regarded as the Chevy level of service. And in any event, using that metaphor, whether it was a Chevy or a Cadillac, it had to be adequate to get the child from point A to point B being the reasonable goal of what was perceived to be the child's ability to accomplish and learn and progress and to be independent. And indeed, even under the old Rowley decision, I would argue that the transition planning rules, which start at the age of 16 nationally and younger in some states, such as Illinois, where it's 14 and a half, the transition planning rules make it absolutely clear that the intention of the IEP, indeed the intention of special ed overall, is to ensure that a child is able to meet legitimate, appropriate post-secondary goals for when they are done with public education, either the end of 12th grade or when they age out, appropriate post-secondary goals. Then you've got to provide services that are sufficient to allow them to meet those post-secondary goals. And many schools didn't. And in fact, many schools wrote and continue to write IEP goals that have no relationship to the post-secondary goals. And that on its face, in my mind, is a denial of a free, appropriate public education. Thankfully, 4 years ago, the US Supreme Court finally, and despite the efforts of our very backward-looking Supreme Court Justice Neil Gorsuch, who was involved in a very bad case on the free, appropriate public education standard, Supreme Court redefined what a free, appropriate public education meant in a way that I think should be interpreted to have a much more expansive definition of what FAPE entails. And that required that the child have an IEP based on their individual needs and circumstances that included challenging goals and objectives. It's like challenging objectives, but I think you have to read that as challenging goals and objectives, and using a term that they called an ambitious program. Well, to me, just using plain English, it's hard to understand that language without seeing that language as requiring something way more than the basic level of service that schools perceive to be necessary under the Rowley versus Hendrick Hudson School District case, and should have resulted in a message nationally that schools should have received and implemented, that it was time for them to finally substantially ramp up the quality and intensity of their programming to more effectively address the needs of individual students, instead of this pathetic, embarrassing, unconscionable commitment to the sum benefit rule, which in my mind is equivalent to saying that our society is going to accept a public education commitment to mediocrity as the goal. That's really what it means. And sadly, so the good news was that the Supreme Court developed this new standard, which was clearly intended to be a stronger and more demanding standard. The bad news is there's been a study that was published about a year ago by one of the law reviews, which a researcher looked at virtually every special ed due process hearing decision and court decision that specifically analyzed a child's rights when the right to a free, appropriate public education was specifically being debated or disputed, and found that the overwhelming majority of hearing officers in courts continue, and school districts, importantly, school districts continue to operate based on the Rowley sum benefit rule instead of based on the challenging goals and objectives rule of the Andrew F. versus Douglas Supreme Court case from 4 years ago. So this is terrible news. All of us who are doing advocacy around the country, I think, are not surprised to learn that's what's happening, because we're observing it's what's happening. But it's kind of a remarkable thing that for once the Supreme Court did something really positive that was a step in the right direction, and the schools and the hearing officers and judges are essentially ignoring it and continuing with standard business as usual.
That's not what I thought it was. It's talking
I'm
more
sorry,
about
Renee Price, I'm going to mute you. Okay. So the good news is you should be using the Andrew F. decision, and it does give us leverage and a basis for argument that's much stronger than the leverage and basis for argument that we had under the old Rowley decision. The bad news is that I wouldn't be super confident that that's going to get a robust interpretation from any hearing officer or judge, or at least the majority of them, if your case actually goes to hearing or trial. Okay, any questions about any of that? Okay, I do see two questions from Melissa Curry that look like good questions. How can those without the budget for advocates best partner with individual educators and administrators to follow 504 IEP, especially when the child's ability to report adherence may be unreliable at times? Very good question. First of all, for better and worse, I don't intend to impugn the intentions or motivations of educators, and especially not the line educators. Many of them want to do a good job. Some of them are not aware of what the law requires, and some of them are aware of what the law requires, but they're under enormous pressure or constraints imposed from above by their administrators. But rather than taking for granted that the educators know the law and are deliberately choosing to violate or ignore the law, I would make a different move and try to open the discussion to find out to what extent they're aware of the law, to share information, to share resources, and to encourage actual collaboration. And to the extent that educators are willing to some degree be brave and step up, because it does require some bravery and courage to do this, it's even possible to offer to the educators, we'll take the fight up to the higher ups on behalf of the child, but it will make it more feasible for us to get what's needed, which will help our child, but also help you if you're willing to stand up and say the things in public that you told us about in private. So sometimes that's a dicey thing for educators, because they're going to get in trouble if they say something publicly that might be contrary to what the administration is believing or advocating for. Okay, when fighting standardized testing, can we include the refusal within the 504? No legitimate legal standard else is fighting. I'm not sure I understand this question. When fighting standardized testing, can we include the refusal within the 504 IEP? I know the legal standards don't fight the testing, but I wonder about success with inclusion in 504. I'm not sure I understand that question. I'm going to take a pass on that. Unless Alyssa Curry, you want to quick try to clarify that. Okay. Then I think we will keep moving, and I'm going to try to wrap this up pretty fast. Just a quick highlight about transition planning. I already touched on that, but there's really no specific set of rules under 504 for transition planning, at least not at a federal level. Transition planning is a very powerful tool under the IDEA And in my estimation, as of the amendments in 2004, it became arguably the most powerful part of IDEA because it has this incredible requirement to develop and build out the IEP in relation to the reasonable post-secondary goals and to base the planning and post-secondary goals on transition assessment that's done at the time that the transition plans are being initially written that cover all aspects of a child's functioning that are necessary for them to be productive, independent adults. So to whatever extent a school might have previously argued that social skills, executive functioning, communication, motor skills, life skills, vocational skills were not educational, or that as long as the kid was getting good grades or achievement test scores, the school didn't have to worry about the result of those other areas. I would argue that if the child's struggling in those other areas, it absolutely creates a strong argument that the school has to substantially ramp up its services in order to meet the post-secondary goals that have been established. And just to highlight this, we've had kids who we've represented who were valedictorians or at the top of their class in terms of grades and achievement test scores, who we were able to force the school to continue to serve for 1 or more years after their senior year because they lacked the life skills to go on to the next stage of their life that they should have been able to do if they'd been given an appropriately robust education that addressed these non-academic areas. Then just very briefly, I don't mean to make light of least restrictive environment, but both the IDEA, ADA, and 504 have specific requirements for kids to be served in the least restrictive environment. I've been involved in many cases involving efforts to get kids fully included in regular education over the years using all 3 laws. Sadly, I would say that the IDEA has become increasingly less useful in relation to promoting inclusive placement for kids with disabilities because of a growing number of court cases that have focused on the extent to which the child's academic and other functioning is out of sync with their age and grade peers. The bigger the gap between the child's performance and the classroom expectation, the less likely the hearing officers or courts will be to order an inclusive placement. So it continues to be easier to get an inclusive program for young kids, but harder and harder to get them for older kids. When a kid is showing problematic behavior that's disruptive to themselves and to the classroom and the teacher's ability to teach, courts are more and more willing to say it's okay to segregate the kids because at a minimum, not only may they get better services, but they won't be disrupting as many kids. So at least that's preferable. And so the inclusive cases are not as successful in my experience at the moment as they were when I was litigating inclusion cases 20 or 30 years ago. ADA and 504, I think there's continues to be a more kind of hard and fast requirement for inclusive or less restrictive options. And the Olmstead case is an example of a Supreme Court case that continues to be useful across the board in both public education and elsewhere in advocating for the rights of people with disabilities to be in the least restrictive environment. Then 2 other things that I want to highlight just very quickly. One is the IDEA doesn't really address the issue of physical accessibility. Someone asked, does 504 require triennial evaluations? The answer is no. Was the valedictorian case you just noted still able to obtain a regular diploma? Absolutely. The fact that you stay beyond 4 years of high school doesn't mean you do or don't get a regular ed diploma, and there shouldn't be an automatic impact in terms of the nature of your diploma just because you require additional years of education. So that would be inappropriate. In Illinois, and this was a very big issue for several kids I've represented who we kept in school beyond 12th grade, they were very upset because they wanted to walk the stage and get their diploma with their peers. And Illinois now has a state law, it's not a federal law, but a state law that says that if a child's not graduating due to their IEP, they still have a right to walk the stage and get an empty get a diploma to participate with their peers, even if they're going to graduate later on. And so that's important to know if you're in a state that allows for that. And it is a concern, in terms of kids' motivation and willingness to cooperate. Obviously, there's also an issue of whether the child has decision-making autonomy and is willing to go along with that, or the parent has guardianship or a delegation of authority and can override the child. But even if the parent overrides the child, if the child's not cooperating and doesn't want to do it, you've got to ask the question, is this going to be successful or not? Iona asked the question, how often is school required to evaluate a student with 504? The answer is periodically, and in any case before any major change is made, but there's, as I indicated earlier, no specific timeline for when evaluations are to be done. And I could spend a lot of time on this, and I'm going to not do that, but just under the IDEA, the procedural safeguards are enormously detailed and include both a whole lot of rules for how a parent is entitled to participate in the IEP process, the eligibility and IEP process, and a whole lot of very specific rules about what's supposed to happen if there's a dispute and the parents are unable to resolve things with the school, which provide for the parent to have a right to both a procedure called mediation and a procedure called a due process hearing, and importantly, require that the hearing officer be neutral and not an employee of the school district. And the school district can't control the appointment of the hearing officers. By contrast, Section 504 has far less detail about how the hearing process works. And as long as the hearing officer is technically neutral, the school is the one who's hiring them. And in my experience, the schools tend to hire their golfing buddies, their neighbors. And in one case I had with the Chicago Public Schools, the school actually hired a woman who had been the director of the legal department of CPS special ed and had retired. And so they brought her back as a hearing officer. And I did file a very angry motion about that. And they ended up, she recused herself and they brought in a more neutral hearing officer. One of the other things that IDEA says very clearly is that if there's a pending request for a due process hearing and it's filed in a timely way, the school district is not allowed to change the child's placement without mutual agreement while that's pending. There is OCR interpretation that allows for the application of stay put placement, but that's not explicitly called for in the regulations. And then there's a whole disciplinary procedure and set of rules under IDEA, again, some of which are duplicated under 504, but with far less specificity, and that include under both laws a provision that you can't suspend or expel a kid for more than 10 days for behavior that's related to their disability or directly due to their disability. It used to be better, it was just related to, now it's due to their disability. Though again, there are more specific rules under the special ed law compared to the rules under OCR, under 504. And then finally, if a parent has a complaint in addition to the request for a due process hearing, they can file a complaint with their state Department of Education to enforce IDEA. That's not available for violations of 504 with the state education department, but by contrast, a parent can file a complaint for violation of 504 with the U.S. Department of Education Office for Civil Rights. And in theory, though it can take a very long time, they can also file a complaint with the U.S. Department of Justice for a violation of the ADA. And we've done that on a very limited number of circumstances before as well. Okay, I think that's going to be the stopping point that I'm going to use. If folks have specific questions now, I'll open it up again for a couple of questions, and otherwise we'll call it a night. Andrea, you just came back on, so hi, and I don't know if that meant you have a question, but if you do, go for it.
I didn't realize I came back on, but hello, Matt. Thank you. I don't have any questions, but I appreciate it. Thanks so much.
No problem. Okay, Well, I'm not seeing any questions showing up, so okay, here we go. Okay, and thanks to everybody. David, special thanks to you. All right.